Hey guys, in our polity static series, we'll do with the emergency provision topic of our polity. So, emergency provision are contained in part 18 and it has article 352 to 360. It talks about emergency provision. So, 352 is about national emergency, 356 is about president rule for constitutional failure, and 360 is for financial emergency, and 365 is also related to president rule, but when the state fails to comply with the direction given by the union. So the comparison will study later. Now what are the changes made after 44th amendment, that is national emergency, the term internal disturbance. Earlier we had the term internal disturbance. So later it was replaced by armed rebellion. Only if we had an armed rebellion, we have to use this national emergency provision. Then we need recommendation from the cabinet in writing. Then approval within 1 month through special majority. We need special majority and it should be within 1 month also. Periodical approval after every 6 months for continuance. Revocation through recommendation of Lok Sabha by simple majority. So if we want to cancel it, Lok Sabha can declare it by simple majority itself. Then rights under Article 19 can only be suspended if national emergency is declared on war or external aggression. So 19 cannot be suspended. In case if we want to suspend it, then there should be some war. In that emergency situation only we can suspend it. Then only laws that are related with emergency cannot be challenged in any court. Then but other laws made during emergency can be challenged for violation of fundamental rights. For example, habeas corpus, it can be like, it will continue to prevail. So, emergency related laws alone cannot be challenged. Then non-suspension of Article 2021. It cannot be suspended, 20 and 21. And then Article 358. Only for Article 19 will have automatic suspension. So under Article 358 only Article 19 will be automatically suspended. And Article 359 it empowers the President to suspend the enforcement of any specified fundamental right. So President will get the power to suspend the fundamental right under Article 359. And then now let's talk about the judicial review. So there are 3 types of emergencies are subjected to judicial review. So these 3 can be challenged. Article 38AA wants to do away with it, but then judicial review is the basic structure, so we cannot take it away from our judiciary. Then national emergency has been declared so far 3 times, that is in 1962, 71 and 1975. These 3 times it's declared. Then Shah Commission. So this was during China's war, Pakistan war, and then during Indira Gandhi period. Shah Commission recommended that to investigate on emergency in 1975. So they were set up to investigate about the 1975 emergency provision. Now next one is about the President's rule. So Article 358 talks about it. There are 2 types like governor can report it or otherwise, and Article 256 union will, under Article 256 union can give direction to state. 355 it's related to center has responsibility to state. 356 president rule. 365 also president rule. So this is case of constitutional failure. This in case of if state did not follow center's guideline or advice or direction. So this is how president rule will happen, during which the government is just dismissed and dissolution of assembly will happen. once Parliament approved it. Now expected to be a dead letter. So Governor's rule was expected to be a dead letter, but it became a deadly weapon later period. Many times it was misused, right? Parliament can delegate the power to make law to the president or any authority specified by him. Laws made by the Parliament President on the state list will continue even after emergency. So, but it can be altered and repealed or reenacted by the state legislature. So, during that particular president rule period, if Parliament enacts a law, it will continue even after the particular president rule. But then state legislature, after coming to power again, they can either alter or repeal it. Now, what are the various judgments? So, what was pronounced by the Supreme Court in our SR Bommai case 1994? The key highlights are: so it said judicial review exists. It shall not be based on the malified, perverse, irrelevant, or extraneous condition. Relevant material is necessary. So, you cannot cancel the judicial review just like that. Then could not look into Court do not look into the correctness of the material, but existence of the material is necessary. So, we are not judging whether your legislation is right or wrong. In that case, we might interfere in legislation, but we are just trying to check if there is something which is existing like that or not. Till Parliament approval, Legislative Assembly is suspended, not dissolved. So, they say under President rule, the Assembly is only suspended, but it is not dissolved. Floor of the House is only the test grounds of confidence. So, floor of the House is only the test ground. Then, anti-secular politics are liable for Article 356. And then, Court can restore, revive the government and the Assembly if proclamation is declared as unconstitutional. So, this is about anti-secular politics. They are also liable, and then court can even restore and revive the government. Now the next one is about the Sarkaria Commission 1988. So what are the acceptable grounds for president rule? So their recommendation are: in case of hung assembly, then failure to follow the constitutional direction, internal subdivision, which is leading to physical breakdown also, and then lack of alternative after no confidence motion is passed. Only in these particular cases the president rule can be implemented. What are the unacceptable grounds? Not giving a chance for alternative after no confidence motion, so we have to give them a chance for other parties, right? Then when a new party comes to power in the Senate, they cannot give president rule in the opposition party ruling state. Then internal disturbances not amounting to internal subvention or physical breakdown. So if there is some disturbance but it is not leading to physical breakdown, in that case also we should not have president rule. Then maladministration or allegations of corruptions, if no prior warning for rectification was given, if used to settle intra-party dispute. All these grounds are taken as unacceptable grounds for president rule. Now, what is the criticism of emergency provision? So, what are the various criticisms? The federal character will be destroyed and the union becomes more powerful. That is one of the concerns. The federal character is getting destroyed. Now, fundamental right loses their significance, can make rulers dictatorial. Then H.B. Kamath says that it is an invitation to totalitarian state. Then K.T. Shah said, a chapter of reaction and retrogression. According to T.T. Krishnamachari, it can even lead to constitutional dictatorship. H.N. Kunzru says it's a serious threat to the financial autonomy of the state. So, these are the various comments by the different people. Now, what is the positive side? So, Alladi Krishna Swami Iyer, he said, the very live birth of the constitution is in this particular thing. So, even state government will be made responsible. So he says it is a very live birth. Then Mahavir Tyagi said it's just acting like a safety valve. Now let's look at the various provision of Part 18, 352 to 360. So here the criteria. What is national emergency? President rule, also known as state emergency or constitutional emergency. Then financial emergency, as like National Recovery Act of USA. So we are going to look at each of them. Now the ground for declaration. So for national emergency, it's war, external aggression, armed rebellion or imminent danger thereof. For president rule, it's either constitutional machinery breakdown on report of governor or otherwise. Or even in case of 365, if state did not follow the directions of center, even that case president rule can be declared. Then threat to financial stability and credibility. Classification, it's classified into internal and external, and here no classification in these two. Written recommendation from the cabinet, it's required for national emergency but it's not required in case of president rule and financial emergency. Now parliamentary approval time and duration. So 1 month is 1 month approval time and indefinite period. It can be held for indefinite period, but we need to renew it or reapprove it every 6 months. Then here 2 months prior notice, like approval within 2 months, and then maximum duration is 3 years. Periodical approval of 6 months is also needed here. Then beyond and here, national emergency or the election commission has to give a certificate that yes, their need for president rule is mandatory in this particular area or state. Then here also it is 2 months and indefinite period, and in case of financial emergency, no intermittent approval is required. So approval time period is 1 month only for national emergency, for other these 2 months. And majority required for approval and revision. So we need special majority only in case of national emergency. For these two, it's simple majority only. Then in case of revocation, president or Lok Sabha with simple majority, they can do it. Then here president can do it, even here president only can do it. But here national emergency can be done even by the Lok Sabha by simple majority. Right? So special session of Lok Sabha has to be convened if 10% of total workers gives a written notice to the president or speaker within 14 days. They have to arrange for a special session. Then what are the consequences? In case of state list, all these things in the state list will get converted into concurrent list. Meaning even parliament can make laws on state list. The fundamental rights can be suspended other than Article 20 and 21. Article 358, it talks about the suspension of fundamental right under Article 19. So this can be done only in case of external aggression or war. Then 359, President suspend fundamental right except Article 2021. Then center can give direction to state on any matter. President can change the constitutional distribution of revenue between center and state. Life of Lok Sabha and Legislative Assembly can be extended by 1 year at a time indefinitely. So life of Lok Sabha can be extended. Then after emergency ceases to operate, it can be extended only to 6 months. So in case of the Lok Sabha term is over, 5 years is over, then the next one has to take place. So the election period can be delayed by 6 months, right? During the emergency period. Then the parliament cannot delegate power to make laws on subject. The assembly can be expanded by 1 year. And after which it can be extended for 6 months. After the emergency ceases, then parliament cannot delegate power to make laws on state subject. Then what about the continuation of laws on state list? Yes, it will not continue after 6 months of revocation. Then imposition It was imposed 3 tries in 1962, 71 and 75. Then we also know President rule in case of Article 365. Failure to comply with the executive direction amount imposition of President rule. Now, what is the consequence of President rule? Parliament makes laws on state list. So, no state legislature will be there. And then governor administers state. No state government exists. After which, no effect on fundamental right. President can confer any authority to send. President issues ordinance on subject in state list. Then Parliament can delegate the power to make law on state subject. These are the various provisions. Like Parliament, it can make law, and the governor will administer the state. Fundamental right will not be affected. Then President only issues ordinance. Parliament can even delegate power to make law. In case of national emergency, it cannot delegate power to make law on state list. Here it can make. This is the difference. Now, regarding the financial emergency, President can give direction for reduction of salary, including judges and other constitutional authority. Then reservation of all money bill and financial bill for the consideration of President, the state money bills even per se. Then direction to the state to observe canons of financial propriety. So, continuation of laws on state level. It will continue and state can amend or repeal them. Here no laws are enacted. It is imposed more than 100 times, whereas the financial emergency has not been declared so far. So, that's all in this emergency provision topic.